Good. All right. Perfect. Welcome to our Monday forms training that we're doing. Again, this quarter, we're covering forms that are associated with our listing agreements. A lot of these double over on your purchase as well. But this one has to do with it's the short sale information and advisory. So some of you may be like, short sale, what the heck is that? Well, they used to be really popular for like a period of time from about 2005 to 2009, maybe 10. There was a lot of short sales. And what that means, in fact, I've got a short sale that I've got listed currently. What that means is that we're attempting to sell the property for less than the property is worth, or not worth, less than what is owed on the property. Okay. So usually what happens in this case is, for whatever reason, the loan amount is more, the loan amount and the commissions and fees or whatever the seller is going to be responsible for amounts to a higher total than the market value of the property. So we're in essence trying to attempt to short sale the property, in that we're going to sell it and the lender is going to be short on the funds needed to close escrow. Okay, so that's what a short sale is. We have the short sale information and advisory. Why is this important? Because when you're trying to short sell a property, what happens is you market the property at the market value or slightly under the market value in an attempt to get an offer. Sometimes you do slightly below the market value in an effort, because we know that this transaction is going to take longer than a normal transaction. And the reason being is, once we get an offer in hand received, then what we have to do is submit a bunch of paperwork over to the lender, and they actually have to approve the sale of that purchase. So they have to say, yes, we're willing to take, a shortfall of $10,000 or $30,000 or $100,000 or whatever it would be. We're willing to accept that short. The ramifications for the buyer is nothing. It runs like a regular transaction, except that once we have the bank approval, you're not generally going to get any more repairs or anything negotiated at that time. So whatever we submit with the original offer, that is what it is. And usually if the bank decides to reduce commissions, then that's usually a split. The reduction is split 50-50 between the listing agent and the selling agent. For your buyers, again, it's going to run like a very similar transaction, except that you can't really negotiate once you're steaming away and we have that bank approval. And it could take 60 to 90 days, I'll say 30 to 90 days to get that bank approval. So the buyer's going to have to be patient and wait a little bit longer. Okay. I've had short sales that I've negotiated that the bank actually refused to sell. So the buyer sat waiting, and we just couldn't get the bank on board to sell the property. They would have rather foreclosed on it. It was a smaller bank. They couldn't accept the amount of losses that they were taking at the time. And sometimes we had short sales back in the day that you would work to negotiate that short sale. It would take the bank 90, 120 days, sometimes 6 months. They move much faster these days. Number one, there's not as many short sales. Number two, they have a little system in place now, where previously there was no system for this. But we would wait, 4 to 6 months for an approval. By the time we got the approval, the values were just plummeting back then. And so, the property lost another $30,000, $40,000, $50,000. We'd have to resubmit it again at the market value so that it would appraise. So it's kind of a mess. But this is your short sale information advisory. This is what you're going to provide as a seller to a potential buyer so that they're aware of the situation. You're going to put the full property address on the top of the property or the document. Remember to put street, drive, road, court, way, boulevard, whatever it is, attached to that full street address. And then make sure you put today's date on there. If you double click on the date, just so you know if there's nothing in there, the quick way to add a date is you just click on it. It was going to automatically add today's date. So if it's blank, that's the fastest way. You don't got to type it in or click on anything. You just double click there and away you go. The short sale information and advisory is intended to give general information regarding short sales, their potential impact, and the rights and responsibilities of the parties involved. It is not intended as legal advice for any particular property owner or buyer. Seller and buyer should consult with their own proper professional advisors for legal, tax, credit, and personal advice. Real estate brokers cannot and will not provide such advice. We are not experts when it comes to tax, legal, credit, or personal advice. Number one, what is a short sale? A short sale is the name used to describe the real estate transaction where the seller's lenders agree to allow the property owner to sell the property for less than the amount of the loan secured by the property. The consent of a seller's lender is necessary because without it, there would not be enough money from the sale to pay off the lenders in full and to pay other costs of the sale. As a result, the lender's liens would remain on title and the seller would be unable to transfer title to a buyer free of monetary liens. Properties that are worth less than the amount owed to the secured lenders are often referred to as being underwater or distressed properties. 2, alternatives to a short sale. Owners of a distressed or underwater properties are faced with difficult choices that could have financial and emotional consequences. Any of the following or other alternatives potentially have negative tax or credit consequences for both for the owner. A loan modification, an arrangement between the borrower and the lender. It can involve a reduction in the interest rate on the loan, a deferment in payments on the loan, an extension of time to pay back the loan, a reduction in principal of the loan, a combination of these possibilities, or other changes to the repayment plan. A loan modification requires the consent of both the lender and the borrower. A foreclosure is a legal process through which the lender acquires title to the property from the borrower who has stopped making payments on a loan. The lender can foreclose whether or not the borrower consents. A deed in lieu of foreclosure occurs when the borrower offers to transfer the property to the lender in lieu of the lender having to go through the foreclosure process, and the lender agrees to accept title to the property from the borrower and forgives the debt. A deed in lieu of foreclosure requires the consent of both lender and borrower. Bankruptcy is a legal action typically filed by a borrower to have debts discharged. An automatic stay occurs as soon as the borrower files bankruptcy, staying all actions against the borrower. While a petition for bankruptcy can have an effect of delaying a foreclosure, it does not necessarily prevent a foreclosure from eventually occurring. No lender consent is required for a borrower to file bankruptcy. Okay, any questions so far? All right. Lender agreement to a short sale. In order for a short sale to be completed, the lender at a minimum must agree to release the property from the lender's lien to allow the sale. The lender may or may not agree to reduce the amount owed to satisfy the debt. If not, the lender may continue to pursue the borrower for the payment of the balance of the debt. Prior to granting approval of the sale, the lender may require the borrower to disclose all the borrower's assets. They may require that a borrower liquidate other assets. They may require that the borrower sign an agreement to repay some or all of the debt at some later time. They may require that the borrower secure an unpaid debt with other assets owned by the borrower. Additionally, they will generally require that the transaction be arm's length. That means you can't sell it to your wife or another family member, arm's length. And that all terms of any benefit conferred on the seller be disclosed, and that the seller cannot stay in the property following the sale. You can't sell it to an investor and rent it back from them. Finally, many first lien holders will limit the amount they will allow to be paid to a second lien holder, further complicating negotiations for the short sale. The lender will usually submit a term sheet to the borrower indicating the terms to which the lender will agree. If a seller and buyer do not modify their contract to comply with the lender's terms, the lender may not permit the short sale to proceed. Sellers are strongly advised to seek legal and tax advice regarding the review of the term sheet. Brokers cannot and will not give legal or tax advice on the lender's term sheet or its effects on the buyer or seller's agreement or on the consequences to the sellers and buyers should they proceed to close. There is no assurance that once the lenders have begun short sale negotiations, they will discontinue the foreclosure process. So if a notice of default's already been filed against the property, we're moving towards a sale date, just telling the lender that we're going to negotiate a short sale does not necessarily stop the foreclosure process. You actually have to petition the lender for a postponement of the sale date. So just a heads up on that. Number 4, seller's continuing liability on the debt. Many borrowers who attempt a short sale are concerned about whether the borrower is released from any further liability to the lender. or whether the lender can pursue the borrower for any unpaid balance of debt. Some refer to continuing liability as a deficiency judgment. Generally speaking, a deficiency judgment is the right of a lender to pursue the borrower for the difference between the amount the lender receives and the amount the borrower owes on the debt. Deficiency judgments in California are prohibited in certain circumstances. For a short sale, 1. Beginning July 15th, 2011, Civil Code of the Procedure 580E provides that any lender who approves a short sale in writing is not permitted to seek or collect a deficiency against the borrower if the loan is secured by a trust deed on residential property containing 1 to 4 units. This law may not be waived. The July 15th, 2011 law does not apply to lien holders on other types of property, a borrower who has committed fraud or waste, or borrowers who are corporations, limited liability companies, or limited partnerships. Prior to this law coming into effect from January 1st, 2011, the restriction on lenders seeking deficiency for approved short sales only applied to lenders holding first trust deed on residential 1 to 4 units. Number 2 is for properties or borrowers to which CCP 580E does not apply. Some lenders negotiating a short sale will want the owner to sign a note for the balance of the unpaid principal. Other lenders will release the lien only, but not forgive the underlying debt. Some lenders will reserve their rights. Thus, in these situations, whether or not a lender retains the right to pursue a deficiency judgment following a short sale becomes negotiable term for each sale. So it's all in the verbiage. Number 3, the seller is encouraged to obtain written agreement from the lenders or other applicable lien holders addressing whether and to what extent seller will be released from any monetary or other claim, obligation, or liability upon approval of the short sale, and have that written agreement reviewed by an attorney, CPA, or other appropriate professional of seller's choosing. B is foreclosure. Purchase money loans. Loans given by lenders to purchase 1 to 4 unit properties, of which 1 will be occupied by the buyer, and seller financed purchases are subject to purchase money anti-deficiency protection rules. Generally, this means that the lender cannot pursue the borrower for any deficiency after the property is foreclosed upon by the seller or lender, or whether the seller or lender uses a non-judicial trustee sale or judicial foreclosure. Refinancing a purchase money loan causes it to lose any purchase money protection it might have. Trust sales. If a lender forecloses by non-judicial trustee sale instead of by judicial foreclosure, that lender is barred from seeking any deficiency from the borrower after the trustee sale, even if the loan was not purchase money. Refinanced liens. The anti-deficiency protections become much less clear for loans that are refinanced. Generally, loans that are refinanced lose their purchase money protection. Lenders extending refinances may be able to pursue a deficiency judgment against the borrower directly following a judicial foreclosure. However, beginning January 1st, 2013, borrowers who refinance a purchase money loan on owner-occupied residential property with 1 to 4 units do not take any cash out from the refinance, receive the same anti-deficiency protection as if the refinance loan was a purchase money loan. So if they're just reducing the rates on their loan doing a refinance, it falls under the protection. Junior liens, that'd be something recorded in second or third position. The anti-deficiency protections for junior lien holders are also somewhat unclear. Junior debt used to purchase the residence, such as a 90-10 first and second, right, where 10% would be the amount of the second loan, would have purchase money protection generally. However, junior liens that are refinanced or junior liens that are used to take out equity do not have purchase money protection. Such non-purchase money junior lien holders may be able to pursue a deficiency judgment against the borrower directly after a trustee sale by the senior lien holders or after judicial foreclosure by the junior lien holder. Although the law is not entirely clear, home equity loans or HELOCs may fall into this category. And 5 is other liens. Many other types of liens may be recorded on the title, including, without limitation, homeowners association liens, judgment liens, tax liens, and child support liens. Generally, foreclosures by any lien holder, seniors, to such liens do not protect the owner of the property from later legal action by the lien holder to collect the obligation, meaning they can record it against something else and they can still go after the seller. Any questions so far on our short sale information advisory? All right. Credit and tax consequences. Credit. All of the owner's options discussed above will most likely have a negative impact on the owner's credit and on the owner's ability to finance or purchase property for some time. The credit impact and length of time an owner would have difficulty in obtaining a loan to purchase property again or to be approved for any other credit transaction, such as obtaining a credit card, leasing an apartment, or even to gain employment varies. Lenders may view short sales and alternatives differently depending on their own underwriting guidelines and those established by governmental or quasi-governmental bodies. To find out more information about the impact to your credit score, go to myfico.com. B, tax. With some exceptions, a reduction or discharge of debt obligation by the lender results in income to the borrower. The income might not be taxable if the debt was being used to acquire, construct, or substantially improve the borrower's primary or principal residence. Another exception exists if the forgiveness of debt results in a situation where the lender is barred from law by collecting the debt, as in a foreclosure of purchase money debt. Insolvency and bankruptcy rules can also shield the borrower from forgiveness of debt income. Generally, when any debt is forgiven by the lender, they are required to provide the buyer a 1099, and it will be up to the borrower to make the proper claim on their tax return to avoid debt forgiveness. To avoid debt forgiveness income. Some of these rules are temporary, and some state laws and federal laws differ. Broker has advised seller that if the lender agrees to accept less than full payment, the difference may result in taxable income to the seller, even though the seller does not receive any cash proceeds from the sale. Seller may also be taxed on the gain of the value of the property from the date the seller's purchased to the date of sale, regardless of the amount of any existing loans or liens. C, professional advice. Seller's advice to discuss with an attorney, CPA, or other professional of the seller's choosing before accepting any offer to present to lender or agreeing to any changes requested by the lender to already accepted contract. Seek legal advice. 6 is potential improprieties. It is an unfortunate reality that many persons, including real estate licensees, mortgage lenders, and attorneys, among others, have taken advantage of owners underwater or distressed properties. Some of these schemes present themselves as rescues of the homeowner, promising to let them stay in the property, protect their credit, and provide payments to them after closing, usually outside of escrow. Both the California Department of Real Estate and the California Attorney General have issued written warnings of potential red flags in short sales and other rescue schemes. Some of these red flags are no license. The DRE believes that real estate license is generally required to negotiate any short sale. MARS, short sale negotiators who do not represent the seller or buyer in a short sale are generally required to comply with the Mortgage Assistant Relief Services rules and provide required disclosures and notices to a seller. Upfront fees. No real estate licensee can collect any upfront fee or advance fee without first having obtained a no objection letter from the DRE, and no upfront fees may be taken for arranging a loan modification. Surcharges charged by third parties that are not disclosed to the short sale lender and usually paid outside of escrow. Third-party negotiations. The licensing and fee requirement above apply whether the negotiation occurs through a broker representing the seller or a buyer in the transaction, or a third-party short sale negotiator. As with other real estate activity, short sale negotiator fees are negotiable and not set by law. The existence, fee, and license status of any third-party short sale negotiator shall be disclosed to the lender and must be approved by the lender as part of the overall compensation to be paid in the short sale transaction. Straw buyers and house flipping. Buyers misrepresent the value of the property to the short sale lender and flip the property to another buyer already in place. Potential red flags include guarantees to stop the foreclosure, instructions not to contact the lender, transfer of title prior to close, often to a trust as a condition of negotiating with the lender. The buyer is an LLC. The buyer wants a power of attorney from the seller, and the buyer hires a third-party negotiator or wants to negotiate directly with the lender. While most of the activities on the above list on their face are not fraudulent, they serve as warning signs that the owner and the real estate agents involved should proceed with caution. Real estate licensees must exercise care and ensure that they are not acting as foreclosure consultants or offering mortgage assistant relief without providing proper notices and disclosures to short sale sellers. Ooh, that was a lot. Buyer considerations. Short sales are often difficult transactions, taking considerably longer than typical real estate transactions to complete. There is no guarantee that the lender or lenders will agree to the terms of the purchase offer or that they will respond in any timely fashion or even respond at all. There is no guarantee that a seller or buyer will agree to any terms proposed by the lender as a condition of releasing the lien or the debt of the property. Buyers may expend money on inspections, loan applications, escrow fees, and other costs that they will not be able to recover from anyone if the lender does not approve the transaction. Buyers may also have difficulty obtaining the return of their deposit in escrow if a seller becomes non-communicative during the short sale process. Generally, sellers also have the right to continue to give offers to their lender, even if they have a contract with an existing buyer. Brokers cannot give any assurances as to what will happen. Buyers are strongly cautioned that any undisclosed and unapproved payments to junior lien holders or to the seller or to outside third-party negotiators may be a form of lender fraud. Buyers are also strongly cautioned that writing offers on more than one short sale property with the intent to purchase only one such property could be a misrepresentation, giving rise to legal claims by a seller, including the claim for the buyer's deposit. 8, National Mortgage Settlement and California Homeowner Bill of Rights. In early 2012, California joined the National Settlement Agreement between 5 of the nation's largest banks: Bank of America, JP Morgan Chase, Wells Fargo, Citigroup, and Ole Financial. And most states, the settlement obligates the lenders, among other things, write down or refinance some loans, extinguish certain unpaid balances, and provide transition assistance to some homeowners. Loans owned by Fannie Mae or Freddie Mac are not covered by the settlement. In fall of 2012, California enacted a series of laws effective January 1st, 2013, commonly and collectively referred to as the California Homeowner Bill of Rights, Homeowners BOR. These laws prohibited foreclosures while an approved short sale is pending or while loan modification is in process or on appeal, as well as other requirements. While a buyer qualifies for any of the advantages of the settlement or homeowner's BOR, requires an analysis of the borrower's loan and its applicability to either of those items. Such analysis is beyond the scope of broker expertise. If a buyer or seller has questions about whether the borrower's loan is covered by either the homeowner BOR or how either of those items can affect the short sale transaction, that party should discuss the matter with a lawyer or accountant of their own choosing. Broker rule. A real estate broker cannot give legal or tax advice in connection with any of the options available to the borrower, nor can the broker suggest what is the best course of action for the owner. Unfortunately, the owner is faced with extremely difficult choices having a lasting impact on the owner. Owners are strongly cautioned that they must seek legal and tax advice in what is not only a choice impacting tax and credit, but also personal issues affecting the owner and often the owner's family. The broker's role is to assist the owner with the actual sale of the property in a short sale transaction and not provide legal or tax advice or to guarantee the best possible outcome for the parties or to assure a buyer that any particular transaction will be completed. Brokers do not and cannot assure either a seller or a buyer will perform on their agreement or that the lenders will agree to any of the terms presented. Brokers are not a party to the contract between the buyer and seller. 10 is broker authority. Seller authorizes broker to market the property for sale, contact lenders concerning lender's approval of the short sale, CAR Form ARC, and seller agrees to give broker any necessary information to negotiate with lenders and advertise in the MLS or other advertising medium that the property transfer sales price and payment of commissions are subject to lender's approval. If lenders will not cooperate, broker may cancel the listing agreement. And then we sign it. At time of listing, you're going to check this box here for the seller's name, put the seller here. You're going to sign as a selling firm. And then at time you enter into contract, you would check the box for buyers, fill in the buyers' names, and then the selling agent is going to sign that bottom section. Any questions about our short sale information and advisory or short sales in general? No, you guys are just all overwhelmed by the short sale information and advisory. Fully understandable. You won't see this come into play very often, but it will come into play. Mark, did you have a question?
I have a quick question for you.
Yeah.
You said that the bank could reduce the commissions.
Yes.
How is that done, or
Yeah, so it's done as part of the written agreement. So what happens, right? We get an offer from somebody, we submit it to the bank for short sale approval. The bank short sale department reviews that purchase contract. And then what the lender's going to do is they're going to produce a document that says, we're willing to move forward with the short sale, and here are the terms. And they will either, approve it or deny. And they may say, hey, instead of, 6% commission, we will approve 5% commission. So you'll know at that time. And then what happens is there's another form. Hold on, let me find it. That outlines kind of that at the time the lender approves the short sale, if there's any modifications to the purchase, which includes commissions, that the contract can be canceled at that time.
that's what I was questioning.
Yeah.
Bye.
So that's your short sale addendum.
Okay, see you next week.
Because that could cost the buyer a few $1,000s more to pay if he has a BRBC with his realtor.
Yeah,
Muy
it
bien,
could.
mamá. A ver, dame la mano.
And hold on, I'm gonna
Dame la mano. No, porque te machuca el carro.
Adriana, can you mute yourself? You unmuted, and I can't seem to mute you. So generally speaking, lenders are aware that they're going to pay commissions to both parties, or at least they had been previously. And so usually they approve like the average commission for the area, or what the bank sees as the average commission for the area. They're usually not unreasonable on that. So usually pretty good. But it could cost the buyer some money, correct, in this day and age. But this is the short sale addendum. So this is what you would attach to the actual purchase agreement. The other one is the listing agreement, information and advisory. It also goes to the buyer, but the short sale information, the short sale addendum, the SSA, is what's included in the purchase agreement. It's only, 1.25 pages. In fact, let's go over this real quick since we're covering short sales today. So that you guys are comfortable with this form as well. So we have the short sale information and advisory, which was like 3 pages of like jargon, right? And then we have our short sale addendum. So this is an addendum to the purchase agreement. We would put the date of the purchase agreement here. So anytime you're making an offer on a short sale, you would include this addendum with that offer. And if it is a short sale and somebody made an offer and did not include this, we would want to counter it with the buyer has reviewed and seen the short sale addendum, or just ask the listing agent to submit it to their buyer so that you can properly review their offer. I'd want this in place up front. The full property address goes on this third line here, and then the buyer's names and the seller's names go on the next 2 lines. Short sale approval. The agreement is contingent upon the seller's receipt and a delivery to buyer of the seller approved written consent, the short sale lender consent to the agreement from all existing secured lenders and lien holders, short sale lenders, by 5 p.m. no later than 45 days after acceptance. So this is the buyer saying, hey, seller, I'm going to give you 45 days to get me the approval of the short sale. Now, obviously there's a blank here. We could fill in 60 days. We could fill in 30 days. And at any time, we could do an extension of time to extend this addendum, okay? Or you could give them to a specific date. Okay, so we could either do a number of days here, or we could check this box and give them to a specific date. So maybe we're saying, hey, we'll hang out until July 31st. Who knows? That's the short sale contingency date. So see, we're adding the short sale contingency to the purchase agreement. Okay, that gives us one additional contingency. If the buyer or seller cancels the agreement prior to the short sale contingency date, that party may be in breach of the agreement unless cancellation is made pursuant to some other paragraph in this addendum or in the agreement, whether or not time periods in the agreement have commenced. Okay, so just be careful with this. We may want to put a date shorter here and then extend it as we're willing to wait versus putting a longer date, especially if you're representing a buyer, because you might be in breach of the contract. The seller can't cancel the contract unless it's by another, pursuant to another paragraph. Short sale lenders' consent means that all short sale lenders are collectively agree to reduce the respective loan balances by an amount sufficient to permit the proceeds from the sale of the property to pay the existing balances on loans secured by the property, real property taxes, brokers' commissions, closing costs, and other monetary obligations. The agreement requires the seller to pay at close of escrow, including but not limited to escrow charges, title charges, documented transfer tax, prorations, retrofit, homeowners association fees and repairs, without requiring the seller to place any funds into escrow or having any continuing obligation to short sale lenders approved by the seller prior to delivery to buyer. C, seller shall deliver to buyer a copy of the short sale lender's consent or term sheet within 3 days after receipt of an approval by seller. Seller's presentation to buyer of short sale lender's consent satisfying 1B removes the contingency in 1A. Okay, if by the short sale contingency date, seller has not received the short sale lender's consent satisfying 1B, seller may in writing cancel the agreement, or buyer has not received a copy of the short sales lender consent satisfying 1B, buyer may cancel the agreement in writing. In either case, buyer shall be entitled to a return of any remaining deposit delivered to escrow. Seller shall reasonably cooperate with existing short sale lenders in the short sale process, but neither seller or buyer is obligated to change the terms of their agreement to satisfy the short sales lender's consent or term sheet. Right? So if there's any changes, nobody's agreeing to those changes. If the short sales lender's written consent or term sheet provided to seller requires changes in the agreement in order to satisfy the terms of 1B, neither buyer nor seller shall be obligated to continue negotiations to satisfy any requirements of the term sheets. Either party may in writing cancel the agreement, and seller is advised to seek legal, accounting, and tax advice before agreeing to any such changes. Both parties must agree in writing to the changes to the written consent or term sheet before continuing under the terms of the agreement. If the agreement is canceled pursuant to this paragraph, buyer shall be entitled to the return of any remaining deposit delivered to escrow. Usually we would do that clarification of the terms on like an AEA, an amendment to the existing agreement. Time periods for the agreement for inspections, contingencies, covenants, and other obligations shall begin the day after the seller delivers buyer short sale lender's consent satisfying 1B and 1F. However, time periods for providing pre-approval, pre-qualification letters, and verification of down payment and closing costs shall nonetheless begin as otherwise specified in the agreement, or if check shall begin as specified in the agreement. That did not make any sense. All right, let's try that again. If time periods for providing, however, time periods for providing pre-approval, pre-qualification letters, and verification of down payment and closing costs shall nonetheless begin as otherwise specified in the agreement, or if check shall begin as specified in the agreement. So under no circumstances do you change those terms. They begin as specified in the agreement. I don't know. The reason that those begin on acceptance, just so you guys know, is that the short sale lender is going to require a copy of the buyer's pre-approval and a copy of the buyer's proof of funds in order to approve that short sale. So that stuff, I don't even know why they've got a box check there. Nobody's probably actually read this form in years and realized that it just states the same thing. So, the time periods, oh, you know what? Here, this is why. The time periods for the agreement for inspections, contingencies, covenants, and other obligations shall begin the day after the seller delivers to buyer the short sales lender's consent. Okay, so it's just covering that. If we check this box, it's just referring to the inspections, contingencies, covenants, and other obligations. So for the most part, those are all going to start once we deliver consent. The buyer's not going to spend money on this property or have appraisals done until we get the approval of that short sale. The things that are going to start immediately are going to be your pre-approval, pre-qualification, proof of funds. That makes sense now. It's just written funny. It almost should be a separate item, but we'll just continue on. Buyer's deposit check. Buyer's deposit check shall be delivered to escrow within 3 business days after seller delivers to buyer short sale lender's consent, satisfying 1B or 1F, or if checked as specified in the agreement. So the default of this one is that that deposit isn't due until we get short sale approval. If we check this box, that would mean that it's due immediately within 3 days of acceptance is the default. No assurance of lender approval. Parties understand that short sale lenders are not obligated to give consent to a short sale, may require a seller to forward any other offer received, and may give consent to other offers. Additionally, short sale lenders may require that in order to obtain their approval for a short sale, some terms of the agreement, such as close of escrow, be amended, or that the seller sign a personal note or some other obligation for all or a portion of the amount of the secured debt reduction. Parties do not have to agree to any short sale lender's proposed terms. Buyers, sellers, and brokers do not have control over whether a short sale lender will consent to a short sale or control over any act, omission, or decision by any short sale lender in the short sale process. Buyer and seller's costs. Party acknowledges that each of them may incur costs in connection with the rights under the obligations of the agreement. These costs may include, but are not limited to, payments for loan applications, inspections, appraisals, and other reports. Such costs will be the sole responsibility of the property incurring them if the short sale lenders do not consent to the transaction or either party cancels the transaction pursuant to the agreement. In other offers, number 6, unless otherwise agreed in writing after buyer's offer has been accepted by the seller, seller has the right to continue to market the property for backup offers. Seller has the right to accept backup offers, and subject to short sale lenders requirements, present short sale lenders any accepted backup offers that are received, and seller shall notify buyer when any backup offers are presented to the short sale lender. 7, credit, legal, and tax advice. Seller is informed that a short sale may have credit or legal consequences and may result in taxable income to seller. Seller is advised to seek advice from a qualified California real estate tax attorney, certified public accountant, or other expert regarding such potential consequences of the short sale. By signing below, parties each acknowledge that they have read, understand, accept, and have received a copy of the short sale addendum. So that's the short sale addendum. It's going to couple with that short sale information advisory on any short sale properties. Questions on the addendum? Nope, we're all good. All right. This kind of works like the same thing that you would see on like the contingency for the sale of the buyer's property or contingency for purchase of replacement property on a transaction, right? We have the ability to decide whether our time frames start now or later, whether the deposits due now or later, and how much time we're going to give them to get that short sale approval. So we want to make sure to include the short sale addendum as well on any offers that we're going to submit on a short sale property. All right. The other document that we were going to cover today, which we still have time, I think we got 15 minutes, we will cover the trust advisory. And this form gets included for any properties being sold by the trustee of a trust. Okay, it's the TA form. You're going to put that property address in the top. Property is being held, and this doesn't matter whether the, the trustee is selling the property that created the trust, right? Like a revocable living trust, or whether it's the trustee that is selling the trust because the owner has passed away. We use this form. Property is being held in a revocable or irrevocable trust for the benefit of those persons or entities named as beneficiaries in the trust. For the purpose of the sale of the property, the trustee of the trust is treated as the seller. Even if the seller is exempt from some obligations, seller must still comply with many others. The advisory is intended to inform buyer and seller of their rights and obligations independent of those established by the contract between them. If the property is placed in a trust, any trustee must complete a TDS and other disclosures that would be required if any such trustee is a natural person, and the trust is a revocable trust, and the trustee is either the former owner of the property or was an occupant in possession of the property within the preceding year. The disclosures are required of any trustee who meets the above requirements, even if the other trustees do not. So as long as one trustee meets any of those requirements or all those requirements, then we have to provide that TDS form. Otherwise, we're going to provide the ESD form, the exempt seller disclosure. Seller must comply with the following. Known, and this is any seller, right? So whether it's the person who lived in the property or who owned the property before it got moved into a trust, or whether it's the trustee selling the property for someone who passed away. Known material fact disclosures. Seller is obligated to disclose known material facts affecting the value and desirability of the property, even if the specific real estate transfer disclosure statement form is not required to be completed. Hazard zones. The seller is not exempt from the applicable statutory obligations to disclose earthquake fault zones, seismic hazard zones, state fire responsibility areas, very high fire hazard severity zones, special flood hazard areas, and flood hazard zones pursuant to the Public Resource Code, Government Code, and United States. Smoke detect, so that means provide the NHD report. Smoke detectors. The sale is not exempt from the state requirements that for single-family residences, operable smoke detectors be in place. It is negotiable between the buyer and the seller who is to pay the cost of compliance, right? If they aren't installed, who pays those? That's in the purchase agreement. Water heaters. The sale is not exempt from the state requirement that water heaters be properly anchored, braced, or strapped, and that the seller provide a written statement of compliance to the buyer. Lead-based paint. Seller is not exempt from their federal obligation to disclose known lead-based paint and hazards on the property. Provide buyer with the pamphlet, Protect Your Family from Lead in Your Home, and give buyer a 10-day opportunity to inspect for lead-based paint hazards if the property contains residential dwelling units and was constructed prior to 1978. Carbon monoxide devices. The sale is not exempt from the state requirement that on or before July 1st, 2011 for all existing single-family dwellings and on or before January 1st, 2013 for all their existing dwelling units, the owner must install a carbon monoxide device approved and listed by the state fire marshal in the dwelling unit if the dwelling unit has a fossil fuel burning heater or appliance, fireplace, or attached garage. Any of those things trigger the need for carbon monoxide. And just for your own personal knowledge, most people get the dual carbon monoxide smoke detectors and they pop those things on the ceiling because smoke floats the ceiling. That's where the smoke detector is required. Just so you know, carbon monoxide actually sinks. It's going to do somebody, by the time there's enough carbon monoxide in that house to trigger that carbon monoxide detector on the ceiling, you're going to have a dead family in the house, just so you know. So you should let your buyers know that although they've met the requirements, that they may want to install one at or below knee level in their house so that it actually picks up on the carbon monoxide, which is going to be closer to the floor. But there's no state rules or regulations as to where that needs to be placed. So just a heads up on that. Water conserving plumbing fixtures. The sale is not exempt from the state requirement that single-family residences built before January 1st, 1994 be equipped with water conserving plumbing fixtures by January 1st, 2017. And multifamily or commercial properties be equipped with water conserving plumbing fixtures by January 1st, 2019. Sellers disclose to buyers the requirements of the law, and sellers disclose to buyers whether the property contains any non-compliant plumbing fixtures. You're going to see that on Car Form WCMD for further information. So again, we don't have to actually install the plumbing fixtures. You're just supposed to disclose whether it does or doesn't have them if it's known. Just so you know, after 1994, you actually couldn't buy any non-compliant fixtures in the state of California. So they're all compliant if they were installed after 1994, for the most part, assuming they got them from a California approved sales place. That's why, like, you can't go on Amazon and order like a high flow faucet to even be delivered to California. Tax withholding. The sale is not exempt from providing information pertaining to the withholding obligation under either the federal FERPTA or the California withholding requirements upon the sale of real property. Federal, for the purposes, a non-resident alien includes a fiduciary. A trustee is treated as a non-resident, even if all beneficiaries are citizens or residents of the United States. State, the trust may be exempt from withholding, but not the completion of the real estate withholding certificate if the trust was revocable prior to the descendant's death, the property was last used as the descendant's principal residence, and the trustee is electing to treat the trust as part of the descendant's estate under IRC 645. See instructions for the FTB Form 593-C. Good luck with that one. They're not exempt from the Megan's Law database disclosure. They're not exempt from the requirement that residential sale contracts containing the following notice regarding the availability of information about registered sex offenders. Notice pursuant to Section 29046 of the Penal Code, information about registered sex offenders is made available to the public via internet website maintained by the Department of Justice at meganslaw.ca.gov. That's in the purchase agreement, so it doesn't have to be a separate disclosure. We just can't take that out of the purchase agreement. Depending on an offender's criminal history, this information will include either the address at which the offender resides or the community of residence and zip code to which he or she resides. Neither sellers nor brokers are required to check the website. If a buyer wants further information, broker recommends that buyer obtain this information from the website during buyer's investigation contingency period. Brokers do not have expertise in this area. So those are all the things that the sellers are still not exempt from, no matter what kind of trust it is. They still must comply with those items. Again, that a transfer disclosure statement is iffy depending on the situation. It may require a TDS or may require an ESD. Sellers may be exempt from the following. A, disclosure statements. Seller, unless specified in 2A2, does not have to complete, sign, or provide buyer with a real estate transfer disclosure statement or natural hazard disclosure statement, TDS or NHD. Seller remains obligated to make the disclosures and comply with the items specified in paragraph 1. If the property has been placed, and remember, the seller still remains obligated to disclose earthquakes, floods, and fire hazards. So we may as well include the NHD report versus the actual form, the NHD form. If a property has been placed into trust, the trustee of the trust is considered the seller for the purpose of complying with disclosure law. Seller must complete and sign and provide buyer with a TDS if the seller, I was just restating what we saw above. If the seller is a natural person, right? So not like a corporation or an LLC. So they're required to provide the TDS if they are a natural person. The trust is a revocable trust, right? Meaning that it was owned by the seller of the property previous to their, as they're trying to sell it, right? What happens upon somebody's death is it goes from a revocable trust, it automatically transfers over to an irrevocable trust, just so you guys know. So if it's a revocable trust, that means the person who put the property in the trust is still alive. And the trustee is either the former owner of the property or was an occupant in possession. So either of those three things, if they all three are true, natural person, it's a revocable trust, and they were the former owner or was an occupant in possession of the property the past year, then the TDS is required. Otherwise, we're going to use that ESD. B, other exemptions. Unless paragraph 2A2 applies, seller is exempt from providing buyer with Melrose District lien disclosure, an Improvement Bond Act of 1915 notice, a supplemental property tax notice, a notice of private transfer fee pursuant to Civil Code 1102, completing and providing either a homeowner or commercial property owner's guide to earthquake safety, including any corresponding form. So those are the other things that they would be an exempt from. Okay, assuming that they're exempt from the TDS. If they're not exempt from the TDS, they're not exempt from any of those things. Okay, that's how that rolls. The exempt seller disclosure. Even exempt sellers have statutory and contractual obligations to make certain disclosures and may or are required by contract to use an exempt seller disclosure and is strongly encouraged to do so. Other considerations, local law. Local law may impose obligations on the transfer of real property, such as the installation of low flow toilets or shower heads, emergency gas shutoff valves, or the installation of smoke detectors. Local law should be consulted to determine if sales by a trustee of a trust are exempt from such requirements. If death, 3B, if a property is being sold because of death of an occupant of the property and the buyer has concerns about the manner, location, or details of the death, the buyer should direct any specific question to seller. 4 is broker's inspection. The sale is not exempt from the broker's obligation to conduct a reasonably competent and diligent visual inspection of the accessible areas of the property and disclose to buyer material facts revealed by such an inspection in the sale of residential property containing 1 to 4 dwelling units. Brokers may do so on CAR Form AVID, AVID. Agency, the sale is not exempt from the obligation to provide agency relationship disclosure and confirmation forms in the sale of residential property containing 1 to 4 dwelling units, commercial property, and vacant land. By signing below, the undersigned acknowledge that each have read, understand, and received a copy of the trust advisory. We're going to sign it at time of listing right here. The seller's going to sign it, and then the buyer's going to sign it down here in the next box once we enter into contract on the property. What questions do we have about the trust advisory? Everybody's got it? We're good to go? All right. I appreciate everyone.
Thank you.
You are welcome, Deborah.
I just had one of these, so it's helpful after the fact.
After the fact.
Yeah, but thank
now
you.
I understand it all.
Exactly. All right. Thank you, Amy.
You're welcome. Thanks everyone for joining me today. I really appreciate it. We covered the short sale information and advisory, the short sale addendum, and then the trust advisory. The short sale information advisory and the trust advisory both get signed at time of listing agreement. The short sale addendum does not have to be, although I would probably go ahead and have my sellers sign that short sale addendum at time of listing and then post it with the rest of my disclosures. Usually I post those in Homelight Listing Management. Thank you so much for joining us today. You can log your attendance in that chat box. There's a link to log it. You can make any recommendations for trainings that you'd like to see coming up in our summer series. I'm really thinking of making it tech heavy this summer. We'll cut down on the number of trainings per week. We'll probably only have 1 or 2 per week. I look forward to seeing you there. Tomorrow at 11, we have our buyer's contract to close coming up. And then on Wednesday, we have Old Republic Title Company coming and talking with us. They'll be in office and on Zoom, and they're talking about assumptions, loan assumptions, whether it be loan, solar, whatever it might be, and how that works as part of the escrow process. So that'll be a great informative training. And then on Wednesday evening, we have social media. We're doing social media lead generation that I skipped a couple weeks ago when I was sick. We'll be covering that this Wednesday evening at 7 p.m. I look forward to seeing you guys later this week. Have a great day.